Good day, attorney. I am Erica Wailunain and this is my recitation video. Section 10. Evidence of written agreements. When the terms of an agreement have been reduced in writing, it is considered as containing all the terms agreed upon, and there can be between the parties and their successors in interest no evidence of such terms other than the contents of the written agreement. Section 11. Interpretation according to its legal meaning. The language of a written agreement is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intended otherwise. Section 12. Instrument construed as to give effect to all provisions. In the construction of an instrument where there are several provisions or particulars, such as construction is, if possible, to be adopted, will give effect to all. Section 13. Interpretation according to intention. General and particular provisions. In the construction of an instrument, the intention of the parties is to be pursued, and when a general and a particular provision are inconsistent, the latter is paramount to the former. So a particular intent will control a general one that is inconsistent with it. Section 14. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in a position of those whose language he or she is to interpret. Section 15. Peculiar signification of terms. The terms of a writing is presumed to have been used in their primary and general acceptation, but the evidence is admissible to show that they have a local, technical, or otherwise peculiar signification and were so used and understood in the particular instance in which the case agreement must be construed accordingly. Section 16. Written words control printed. When an instrument consists partly of written words and partly of a printed form, and the following are inconsistent, the former controls the latter. Section 17. Experts and interpreters to be used in explaining certain writings. When the characters in which an instrument is written and difficult to be deciphered, or the language is not understood by the court, the evidence of persons skilled in deciphering the characters or who understand the language is admissible to declare the characters of the meaning of the language. Section 18. Of two constructions which preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he or she is supposed the other understood it. And when different constructions of a provisions are otherwise equally proper, that is to be taken which is the most favorable to the party in whose favor the provision was made. Section 19. Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one in favor of natural right and the other against it, the former is to be adopted. Section 19. Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one in favor of natural right and the other against it, the former is to be adopted. Section 20. Interpretation according to usage. An instrument may be construed according to usage in order to determine its true character. Section 21. Witnesses, their qualifications. All persons who can perceive and perceiving can make known their perception to others may be witnesses. Religious or political belief, interest in the outcome of the case, or conviction of a crime, unless otherwise provided by law, shall not be a ground for disqualification. Section 22. Testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived of his or her own perception. Section 23. Disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. Section 24. Disqualification by reason of privileged communications. The following persons cannot testify as to matters learned in confidence in the following cases: A. the husband or the wife, or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one form of the other during the marriage, except in a civil case by one against the other, or in a criminal case for crime committed by one against the other, or the latter's direct descendants or ascendants. Section 25. Parental and filial privilege. No person shall be compelled to testify against his or her parents, other direct descendants, children, or other descendants, except when which the testimony is indispensable in a crime against that person, or by one parent against the other. Section 26. Privilege relating to trade secrets. A person cannot be compelled to testify about any trade secret unless the non-disclosure will conceal fraud or other work injustice. When disclosure is directed, the court shall take such protective measures as the interest of the owner of the trade secret and of the parties ends. Further of justice may require.